Following our last video on the disclosure of building safety information requirements, another regulatory requirement tackled by the Building Safety Act 2022, or the BSA, is the use of unsafe cladding materials in high-risk buildings. The developers of these buildings are now compelled to take steps to remove or replace the unsafe cladding. Landlords are now required to disclose, via a landlord certificate, whether the leaseholder's lease is a qualifying lease. In the case of a qualifying lease, the developer has to cover all the remediation costs or otherwise confirm whether there are any remediation costs to be passed onto the leaseholder. This is significant for buyers as they may be required to pay for the remediation or replacement works depending on whether or not the lease is considered a qualifying lease. It is essential for a buyer's conveyancer to obtain a copy of the landlord certificate to determine whether the buyer would be liable to pay for any remediation works, and their failure to do so might result in a lender refusing to provide the buyer with a loan or may affect the saleability of the property to a potential buyer in the future. In conclusion, the BSA is a landmark piece of legislation that encompasses a wide range of issues concerning building safety. The matters discussed in the video are only a few of the key takeaways from the legislation. Buyers of properties in high-rise buildings are encouraged to seek professional legal advice to ensure that they are properly advised of the protections they are afforded under statute and to ensure that the proper regulatory requirements are complied with. This will help to ensure that they do not encounter any issues trying to sell the property or secure a mortgage against it in the future. Thank you for watching. Like and follow us for more property-related videos like this one.